Ronnie, you remember when I started, I said the way out is to have the national interest of Ghana at heart. That's how we will have a way out.
Right.
I was thinking that my good friend here would probably fully agree with that and even start pursuing it now. For example, ask why Parliament is not sitting. In every jurisdiction, there's often what we call res judicata. So res judicata means that somebody must have a last say. Mm-hmm. And as I mentioned earlier, the International Court of Justice recognized, they call it general principles of law recognized by civilized nations. Mm-hmm. Somebody would always have to have a last say. Mm-hmm. It doesn't mean what they said is right or wrong. Mm-hmm. That's not how we assess it. Once they have the last say, we all move on. Now, in our situation, we have given the Supreme Court under Article 2 the last say. That once they mention it, it doesn't matter. The decision could, even the substantive matter, it could turn out that the Speaker was right all along. But in the interim, they have given us a say. And the say is that they have ordered a stay. The status quo, the decision has been frozen. And that we should return back to the status quo.
Mm. I just want to know, what are you answering to? Is it because you referred to
yes, Parliament. When you said the MPPs refused to come, there were about 15 in Parliament. Is that what you mentioned?
Yeah, yes.
And you don't know why they refused to come. So when that order was made, from my understanding, all that the Speaker needed to do was to communicate behind the scene to the various parties, the MPP, the NDC, that I have received an order from the court, and the court decision prevails over any other decision, and therefore return to Parliament and take your rightful positions. Okay. If you listen to the media, ask why the MPP members were not in Parliament. I think you're making very clear that they did not want to repeat what happened at the beginning of the Parliament.
The Speaker said that
he
was not properly served.
Okay.
He went to the court. He made that case before the court.
Okay.
The CJ, in reading the decision, told us that perhaps the Speaker misinterpreted the circular.
Okay.
But we have seen the circular. We've put the circular out there.
Okay.
What we were told in court,
and
what the circular says are two completely are two completely different issues.
Yes.
And I'm only raising this issue because I do not think that the issue of the Speaker saying that he was not properly served on the basis of the circular.
Yes.
I have been convinced that the Speaker was wrong.
Okay.
But just to give you some information so that you continue.
Okay.
See, but what he is trying to say
is
about the fact that there was already a ruling, that there had been a stay of the execution.
Of the execution.
And therefore, we needed to stay it whilst the substantive case was
just needed to obey the
But see, you know the interesting part of it?
Yes.
That day that Mr. Speaker adjourned,
yes.
Usually they go into what they call conclave. Leadership will go into it and deal with some issues that may not necessarily have to come to the floor of the House.
Yes.
In the course of that discussion, Afenyo Markin insisted that Mr. Speaker gives his standing on the stay as to whether he was going to respect it or not.
Okay.
In the conclave. And then Mr. Speaker said, I made my decision at plenary.
Okay.
Let's go to plenary. And I will make my decision there. Afenyo Markin said he was not ready to come in there until, so they were going into their offices to sit there, monitor Mr. Speaker's utterances. Then on the strength of that, they will know whether to come back.
You've clarified.
You understand?
You've clarified.
But unfortunately, we didn't even have the numbers for Mr. Speaker to do that. So Mr. Speaker adjourned.
That's why I said, so if you have the national interest, the approach taken by the Speaker was wrong. As I said, the court have the last say. All that you needed to do was to implement.
Why was it wrong?
Why was it wrong?
Sorry?
Why was it wrong?
The decision that you have to come to Parliament, you then have the number before you make it.
No, that's not.
It means that you have more or less say you have the last say. You have to make a decision.
No,
he doesn't have to make a decision.
Yes. You have a situation where the Speaker has conducted parliamentary sitting.
Okay.
A decision has been taken.
Yes. He made the decision, not Parliament.
No, just hold on. A decision has been taken.
Yes.
He hits it. Is it gavel you call it?
Yes.
He hits it.
Yes.
He ends the matter.
Yes.
Somebody goes to court.
Yes.
And the person says that the Speaker and Parliament were wrong.
Okay.
Because as far as he's concerned,
yes,
by Parliament's own standing orders and everything,
yes,
Parliament did not have the required numbers to have conducted business.
Yes.
The court
yes.
agreed with the person, in this case, Justice Abdullahi.
Okay.
If you were a speaker,
yes,
would you not be also interested in conducting business in accordance?
Randy, there is difference between Parliament decision and Speaker decision.
What do you mean by
yes, this one was a Speaker decision. It wasn't a decision by the Parliament. Parliamentary decision would be where a vote has taken place by both parliamentarians. The end result pronounced by the Speaker is a parliamentary decision.
Actually, I think you are misinforming.
No,
you are misinforming the public.
Let me come. This thing. So it was the Speaker who made it. It wasn't like a Parliament that had voted on it, and the court would have the last say. And once the court gives that particular order, it takes immediate effect. If you look at Article 2 very, very carefully. So it doesn't need further decision to be made by the Speaker.
You see, what I was drawing your attention to, what I was drawing your attention to is that if you look at the Speaker's case before the Supreme Court,
Yes.
it presupposes that the Speaker, at the time that the injunction or whatever was given, the Speaker did not believe that he had been properly.
Let's leave that aside.
No, do you get the point I'm making?
Yeah,
I'm saying that until this current decision by the Supreme Court, as far as that grant of injunction was concerned, the Speaker believed that he had not been served in accordance with what had been agreed.
Yeah, but actually, I don't want us to drag on this.
No, I'm just
regardless of the Speaker.
Chief, I'm just raising that because it would be unfair to say that the Speaker was wrong if you do not factor in.
Regardless of whether he was served properly or not, he had a constructive notice at least that this is the order of the court. And that constructive notice is enough. He has to act in good faith. But to hide on technicalities, whether you have been, well, the way forward on Thursday, he has now been properly served. He has challenged the decision has been rejected. So now that it has been rejected, we expect him on Thursday to fully implement the order of the court. Can we all accept that? That there is stay of execution, and therefore those parliamentarians who were asked to go home by virtue of the decision of the Speaker.
Who asked them to go?
You are misinforming the public. We did not say go home because of the decision of the court. We did not have a quorum to take decisions.
No. I'm talking about the original decision that the Speaker excluded the 4 members of Parliament.
Those 4?
Yes. Okay. So I'm saying that the stay is now in place. Now that the court have rejected the Speaker's application, we expect on Thursday that he would do as the court asked him to do. Can we that one clear? Good. And we don't have to play politics with that as well.
Right.